Hello, everyone. Thank you for joining us for NKU's estate planning workshop today. People are still coming into the webinar, so we're going to give them just a couple of minutes here to join, and we'll be back to it in just a moment. Thank you for your patience. Just in case you might have just joined, we're going to start the NKU's estate planning workshop momentarily. We're going to give everyone about another minute or so to join and make sure that we get people in here that want to be in here for the very beginning. Thank you for your patience. Okay, we're going to give it about 20 more seconds here to let people join, and then we'll get it started. Okay, I think we've got a lot of people on the call already and we're ready to go. So we'll go ahead and get it kicked off. Thank you for joining NKU's estate planning workshop. We're hopeful that today's presentation will provide you with some information to improve your estate plan so that you can enjoy peace of mind that your wishes will be followed, whether it's leaving your assets to family or supporting your favorite causes like NKU. My name is Kyle Higgison, Director of Gift Planning. This presentation is brought to you by my Office of Gift Planning and NKU's Office of Alumni Engagement and Annual Giving, where Amy Wiley serves as Senior Director. As you participate in today's presentation, please consider other topics you would like to see presented in future workshops. We are really excited to have Johnson Investments providing the content for this workshop. Johnson Investments is presenting to us today free of charge as a service to our alumni and friends. Our presenter is happy to answer questions during the course of the workshop. Please feel free to type your question and send it to us utilizing the question tab. Again, please use the question tab. Amy will facilitate these questions periodically during the course of the workshop. And now, let me introduce to you our guest speaker today, Mary Burns. Mary has been with Johnson Trust Company for over 10 years. She grew up in Cincinnati and graduated from Chase College of Law, as did her husband. She's been practicing law in the areas of estate planning and trust and estate administration for close to 20 years. Mary has been on the planning side and the administration side of trusts and estates. While in private practice, she advised clients on their estate plans and drafted and helped implement those plans. While at Johnson, she's continued to advise Johnson Investment Counsel clients regarding their estate planning, and she also serves as in-house counsel for Johnson Trust Company as corporate trustee. Mary, thank you so much for being here today and helping our NKU community plan for their future. Take it away.
Thanks, Kyle. It is my pleasure to be here. I want to make sure you can hear me, so signal me if you can't. We're going to go ahead and just jump right into it. I want to say that I have an agenda today, so we'll move to the agenda slide. And just a little bit about Johnson Investment Counsel. We have offices in Cincinnati, 2 offices in Cincinnati, Dayton, Columbus, Cleveland, and in Michigan as well. So I am licensed in Kentucky and Ohio. So a lot of this will focus on those. I don't know where people are zooming in from, but it will be a focus on Ohio and Kentucky today. I am pleased to be here. I enjoy helping people figure out really what it is that is important to them with respect to their family and their assets. Really, an estate plan is figuring out what people want for their family, and I think, or for their causes that are important to them. So today is going to be an overview of estate planning that I think applies to everybody. So we're going to cover who needs an estate plan. And some people say, oh, I don't need an estate plan. I have a house and a car. I don't really need anything. I've got a 401k, or even I don't need an estate plan because it's all going to go to my kids, right? So maybe we'll talk about that. We're going to talk about what documents should really be in every person's estate plan, regardless of wealth, regardless of what your intentions are. We will talk about why you might need a trust. I think that a lot of people think they don't. Again, you do not need to be wealthy to take advantage of some of the things that trusts allow. And then when should you review your estate plan? Some people find that they come to me and say, oh, I have an estate plan, but their estate plan actually names guardian for their children, and their children have children now at this point. So it's probably past time to review their estate plan. And we will have time for question and answer. I will say, to the extent that people want to ask questions throughout, I would echo what Kyle said, just because let's have the questions as we go along, just to make sure that people are following and that I address anything that might have been confusing. So let's go to the next slide. I think that it's important to define when I say wealthy, what does that mean? Some of us would believe that all of us are wealthy here in America, and other people would say otherwise. So I think that it's important to understand just really high level what the federal estate and gift tax regime says. Currently, each person can pass at death or in life over $11 million. So a married couple can pass $12 million at their death a married couple can pass over $22 million without incurring any federal estate tax. That's a lot of money. That's not a lot of people. But that's not the only people who need trust. So I just thought that was good for a high level overview. Just as an aside, that amount is scheduled to go down at the end of 2025. So when we come to 2026, that amount is going to go back to the exclusion amount that people can pass free of estate tax that was set in 2012 under President Obama's Taxpayer Relief Act. So in 2026, it'll be indexed. Rough figures are that's about $12 million that a married couple can pass. So it'll go in half of what it is now. So to the extent we have anybody on the phone who's listening that those numbers are important, I think that let's look for 2025. Biden's tax plan, from the looks of it, would bring that sunset sooner. So that's something we're keeping an eye on here at Johnson. And of course, a person can give anybody $15,000 per year without any estate and gift tax consequences. That's all I really want to talk about, estate and gift tax, just because I really want to keep this applicable to everybody, and that doesn't apply to everybody. I'm more than happy if people after this session want to email me with questions specific to them. I'm happy to talk through their situation and get them to the right attorney if that's appropriate. So let's move on to the next slide then, since we've covered the estate and gift tax. The way that I like to help people frame how to go about their estate planning is the first question is, how much wealth do you need to retain during your life to feel financially secure? Because you may be thinking, I want to give some gifts to children or to charity, and how can I do that? And really that depends on what do you need to retain to feel secure. That might not be just a projection on a spreadsheet about what your financial advisor says, although that's important and you should have that conversation. Sometimes it's just, what do I need to sleep at night? And that's a valid concern. You should pay attention to that. But if once you work through that answer, you need to think about what is appropriate to transfer to family. I think sometimes people assume that everything should go to their family, but some people are uncomfortable with that. I think that it's also important to say, when should those assets be transferred and how, given unique family circumstances. We'll talk about some of those circumstances today, some things to look out for. I think that also we want to make sure that before we leave people wealth, that we're transferring wisdom to them so that they know what to do with that wealth. And that's just a valuable conversation to have. And again, I'm using wealth really broadly here. If you have a house and a 401k to pass to someone who's going to get that in a lump sum, that's newfound wealth to someone. So I don't think that it's just $11.58 million that we need to talk about. I think it's any sort of unexpected windfall that somebody might receive through an inheritance. And then you can think about whether you want to make charitable gifts, say to NKU. When would you like to make those gifts? Do you want to do it during life or do you want to do it during death? And there are ways to do that advantageously for both you and the charity. So I'll touch on those a little bit later as well. So those are just some high level things to start thinking about when it becomes appropriate for you to think about how should I think about estate planning. I think this is a good way to get started. So let's go to the next slide where I've outlined really the basic estate planning documents, and we'll just stay on this slide for a minute or more. These are documents that, regardless of your level of wealth, I think are important for people to have. And I'll go through each one of them, explain what they are and what they do and why they're important for everybody. A power of attorney is sometimes called a durable power of attorney, sometimes called a financial power of attorney or general power of attorney. This is a document where you're giving somebody the ability to act for you. There are two kinds. You can have one that goes into effect as soon as you sign it, and you can have something that's called a springing power of attorney, which is a power of attorney that doesn't spring into being until some event has occurred that's outlined in that document. So let's say, for example, you want to name somebody as agent for you. You want to give them power of attorney over your financial assets, but you don't want them to have that power until you become incapacitated. In that case, you might sign a springing power of attorney. A couple of things that attorneys will use, you can either provide that maybe two doctors must have declared you unable to manage your own affairs, and those letters from those doctors must be attached to that power of attorney. It can be a court order. I highly recommend the doctor note route so you don't have to go through a court process to have a judge declare you incapacitated. That is a hard process to go through for your family and everybody involved, including you. Or you can have a power of attorney where you're just naming someone right away and giving them agency. So a lot of times married couples will do this. For example, I've given my husband power of attorney for me. This has proven one of the most useful documents that we have in our estate plan. We use this for situations where one of us needs to sell our car, and but the person who's got title to that car just doesn't have the time right that second to sell it or transfer it for whatever reason. He's handled the last car sale that was in my name because he had power of attorney. We've also used it when we go through refinancing our house, our mortgage. Just one of you has to go to the closing then for the refi. It's just kind of a handy thing to have, I think, in life, even when there's not an incapacity issue. It's just kind of a convenience issue for some married couples. So that's an important document. That document will control things in your own name. we're going to put trusts aside. We'll come back to that. But if an asset is in your name, this document will give the person the ability to act over that. It can be like an IRA, your house, your car, things like that. The next two things there kind of go together, a healthcare power of attorney and a living will. I'm going to talk about them separately, but just as a point, Kentucky has a combined document. They call it a living will and a healthcare surrogate appointment. And then Ohio has a healthcare power of attorney and a living will. Every state is going to do things differently. I recommend that if you move from one state, first of all, your documents will be honored in the state that you move. Let's say you live in Ohio and you move to Florida. This happens for a lot of people. Your documents will be honored. I will say that because each state's bar community and medical community get together and kind of put together a document that's recognized in that state, you might think about going to have an attorney review your documents and get you documents that the healthcare professionals in your new area will be familiar with, just as a point of ease. I don't think it's crucial, but that's just a piece of advice that seems to have come up over the years. But a healthcare power of attorney or an agency surrogate designation is a document that, like the financial power of attorney, gives somebody the authority to act for you over healthcare decisions, though not financial decisions. It is a pretty broad scope. There are some things in the document that you will call out regarding specific types of treatments. But this is going to be a document that if you are in a situation where you cannot make healthcare decisions for yourself, that's when this document goes into effect. So it's not like the financial power of attorney where you can say, oh, sure, let this person make healthcare decisions for me at any time. That's not possible. This will be something that a doctor will say, we need to make a healthcare decision now, and this person is not able to. It could be long-term if there is some permanent incapacity and someone needs to have the ability to care for you. It could also be just temporary. Let's say that I was in surgery and the doctors found something. My husband is named as my healthcare power of attorney, and he would be the one to make a decision if something needed to happen urgently. I will say for the married couples out there, this is a situation where while your finances might be tied up more together, and so in your financial power of attorney, you might have named each other and then the same person as an alternate agent. I'm far more comfortable with people naming different alternate agents. Married couples very often will name each other, but then we'll name an alternate. And for example, my husband and I have different people named as our alternates because those are really personal decisions about your body and your life. So there should be somebody that you trust implicitly with those decisions. I will say also that the financial and the healthcare power of attorney do not need to be the same person. Of very frequent occurrences that a married couple will come in and will name adult children in these roles as alternates for each other. And what I tell people is that you might have someone who you trust with your checkbook, but that might not be the same person that you trust with your healthcare decisions, and that's completely okay. Also, it gives, if you have more than one child, it helps share the load as well, so they can work together on things. So that's the healthcare power of attorney. It's an agency document. The living will is a document that is a directive. The living will is the document where you set forth your end of life decisions, or decisions you'd like to make with respect to end of life treatment is a better way to say it. So if I've been given life-sustaining treatment and the doctors come and tell my husband that we've come to a point in the road where this life-sustaining treatment is keeping me alive, but I am not coming back, and they will have their very precise terms based on whatever is the specific situation. The doctors will say, we've come to a point where you might consider looking at the living will and finding out if there should be an end of life sustaining treatment, or it may be that life sustaining treatment will need to be given in order to continue life. And so the living will can control also not giving any life sustaining treatment, or it can involve the withdrawal of life sustaining treatment. This can be this and the healthcare document can be one of the documents that's hardest to sign in the estate planning meeting where you sign everything. You will get it ahead of time. It's worth looking over to read and be comfortable with what you're signing. I will say these documents are not going to control in the event. Let me back up. I'm addressing people who come and say, what if I'm in a car accident and I need life-sustaining treatment to survive? If you go to the emergency room's mandate is to save your life, and that is what they will do. And then after a period of time, there may come a time when the living will has to be called into question. But if there's an accident or some kind of event and you go to the hospital, again, they're going to save your life. It's going to be later that a decision needs to be made. I'm going to pause there to see if there are any questions about these three documents. Amy, I don't know if you have any. We might be a little early on, but just checking.
No questions at this time, Mary.
Perfect. One might think that if you've given someone the ability to act for you with a healthcare power of attorney, that they can request your medical documents, something that they would need in order to make healthcare decisions for you, but that is not always the case. There is a healthcare information release form that a lot of attorneys are using. It's called a HIPAA waiver too. Your doctor's office may have provided you one that you may have signed saying where they can release healthcare information to. And if it's something your attorney can give you, I would recommend it just in case there's ever a snafu and some kind of medical provider doesn't believe they can provide medical documents. I think that if somebody has the authority to act on your behalf, they should be able to get it, but that's not always the case. So we put that in there as one of the basic documents that makes sense to have. And finally, probably what most of you came on here to hear about, what is a will? What does the will do? A will is the document that controls those assets that are in your individual name and where you do not have a joint owner or a beneficiary designation. So again, the will is only going to control assets that are in your name with no beneficiary designation and no joint owner. So let me give you a couple of examples. I own my house jointly with my husband with rights of survivorship. Rights of survivorship is a key phrase you want to check on your deed to make sure you have if you own something jointly with your spouse or anybody. And rights of survivorship are important. What that means is that if I die, because my husband owns it with me with rights of survivorship, upon my passing, his interest just swells and he, as a matter of law, owns the entire piece of property. An affidavit can be filed explaining that he does own the property, but there's nothing that he has to go through to take full ownership. If we owned the house, if it was just in my name, my husband's an attorney as well, and we decided that the house should be in my name for liability purposes. If I die and the house is in my name, then in order to get it to him, because my will says everything goes to him, he's going to have to go through probate, which we'll talk about in just a second, to get that house. Again, if people think about what they own, the will may not control as much as you think it does. For example, retirement accounts, like 401ks, IRAs, other qualified plans. If you're at NKU, then you have the academic version of the 401k. And those, even though you might not have a beneficiary named, you'll want to check those contracts that you have with them. Check your application, because that application will say where those assets go upon your death, even if you don't name a beneficiary. So that's important to check your beneficiary designations here as well. Sometimes the financial institution will say, upon the death of the owner, this should go to the estate, in which case your will would control that. That's not a great result for a lot of reasons, but I think it's always better to name a beneficiary when you can get something to somebody directly without any probate. Let's talk about probate just for a moment. Probate is the process that I just described. It's how you get assets in your individual name to people named in your will. It's a court process. It is public record. You have to file an inventory listing what is in your probate estate, which again are the assets that will be in your individual name with no beneficiary or joint owner. In Kentucky, in order to be sworn in as executor, the executor is the person who is in charge of your probate estate, you have to go to court. So I would point out that that is a time when somebody has died and there is grief involved, and then to go to court in that time is kind of daunting and overwhelming. The Northern Kentucky probate court judges are great, and a lot of them even meet in chambers, depending on your county, to make it a little less intimidating. But I still think if we can save people from that process, we should. I would also say the Ohio probate process is not an easy one. There are a lot of forms. It's pretty intensive. It can be expensive. Both probate procedures can be expensive. I would suggest that in order to avoid that process, you think about establishing a trust. I'm going to check one more time for questions since I just threw a whole lot about probate. So Amy, if there's a question you think it's a good time to ask, let me know.
I do have a couple questions.
Okay.
So to go back to earlier conversation, can you recap the combined Kentucky documents that you referenced earlier? Was it the living will and healthcare maybe? Yes.
The Kentucky documents that are combined are the healthcare surrogate designation and living will. That's what on this screen, it says healthcare power of attorney and living will. And in Kentucky, it's a combined healthcare surrogate designation / living will.
Okay, thank you. And then one more. The documents you just discussed, besides providing these documents to our doctors, do we need to file them with the state via an attorney? And then what are the rough estimated cost in hours if we utilize an attorney?
Gotcha. You do not need to file these with the state. You'll want to have your healthcare provider have them. Hospitals will ask if you have them when you check in. Interestingly, the last time I went into the hospital and they asked me if I had a living will and healthcare power of attorney, they just wanted to know that I did. I said, sure, I can give you a copy. They said, that's okay. We just want to know if you have them. So I do. But you shouldn't have to file them anywhere. That reminds me of something though. The power of attorney, the financial power of attorney, if you're going to use it for real estate, you will have to record that, much like as part of the process of filing your deed or your mortgage. The power of attorney is going to have to be filed as well, so that a title examiner makes sure that the person signing on your behalf has the authority to do so, and the power of attorney will outline that authority. So thanks for that question, since it reminded me of that. And then you asked, what are the fees for an attorney? I will give a very attorney answer, which is it depends. Part of it is that it depends on what your individual needs are and what documents you're going to have to be required to have. So I am very hesitant to give you a figure. It's going to vary based on everybody's particular situation and needs, and what the whole process looks like for your attorney. Some attorneys will charge a flat fee. After talking to you, they'll say, after talking to you, here's what we charge. Some of them will just have a flat fee in general. They won't even need to talk to you and say, here's how much I charge for a package such as this. Some attorneys will talk to you and can give you an estimate. My recommendation would be that when you contact an attorney and you talk to them, that you ask them, how much does this typically cost? How much do you think it would cost for me? And ask for an estimate so that you know. It's also perfectly fair to say, if you're not using a flat fee, I think it's a fair question to say, if we're working from an estimate, could you tell me when we get close to that estimate? And I say that because if it's an estimate, then they are billing for their time, which is how attorneys bill. So if you can ask for a heads up if perhaps you feel like you've had a lot of conversations with them, or you know that they're doing some work in the background that is going to take up time. If you want a heads up that we're getting close to, let's say, the $1,500 that we talked about or something like that, that's fair to ask. I always tried to give, when I was in private practice, I tried to give an estimate. I personally didn't use a flat fee, but I did try to give an estimate so that people would know what to expect. And I tried to do that within the first conversation to understand what it was they need and what their thinking was, so that I have an idea of what documents to prepare. A trust will add some money to that, but what I will say is that a trust's cost will be made up for in the probate avoidance sense. You might not feel the cost of probate, but your family will, just because they'll have to have court fees and pay an attorney to handle the estate and for their time then. And if something comes up, then that'll just add to it. I think that it's well worth the cost. I have yet to see a time when a trust wasn't a good idea with respect to making administration easier and less expensive. Did that address the question, Amy? I want to make sure I got them all. Okay.
Yes, and I think Kyle has a question here too.
Okay, yeah. Great.
Mary, in our previous workshop, someone had sent in a message that I believe it was something along the lines that they got guidance from an attorney to essentially unwind their trust, and you know, just put these things in their estate because the probate process in Kentucky is so easy. I'm just wondering, I've always kind of heard that if you can avoid probate, you want to, because it is such a public process and costly and time consuming and everything else. You know, we don't know the entirety of that situation that I just described to you, but maybe if you could talk about that a little bit, it might be helpful to clear things up if anybody's joining from our last one.
Yeah, that is an interesting question. My caveat is that I do not know the particular circumstances of that situation. So I'm not sure what prompted the attorney to give that advice. I always want to know the full story before I opine. So my response would be, Kentucky probate is less onerous than a lot of states, but the Kentucky probate process is still, as I said, public information. It is still something that really is an experience that I think for families left behind, if you can avoid them having to go to court and deal with court deadlines and filings, it seems like in most cases, I'd want to avoid that. Again, I don't know what was happening in this particular circumstance, so I don't want to step in the way of an attorney giving advice to a particular client. My advice to clients in private practice and today is, if you can avoid probate, avoid probate. There are lots of good reasons for a trust. Number one of which is probate avoidance. I think that, yeah, I think it's expensive. I think it's difficult. And I think that it's very easy to avoid. So unless there's some extenuating circumstances where public oversight is desired, I would avoid it. Some people have asked me, well, I want the probate court to have jurisdiction to be able to step in. And my response to that would be, the probate court always has jurisdiction over trusts. They are the main court that does. So if you have a living trust or a revocable trust, which is what I would be recommending for people just for probate avoidance, a beneficiary or a party who has a grievance against a trustee or something happening in the trust has the jurisdiction or has the venue of the jurisdiction of the probate court to go to. So in my mind, and if a trust already existed, it's interesting advice to me that they would suggest unwinding it and just going through probate. I personally don't understand that, but again, perhaps there is something in that particular situation that warranted that piece of advice to somebody. I hope that addresses that very interesting question.
Mary, what it was in reference to is that the person who posed the question put their house in a trust and wanted to pay taxes and insurance. And I think they implied that it would be cheaper to set up that trust in probate than probate. But
so go ahead.
So I just wanted you to know the context, the person providing.
So here's what I tell people. Sometimes there's a mortgage on a piece of property and you don't want it, and transferring it to trust might cause complications there. If it's a revocable trust, then a revocable trust is disregarded for tax purposes. And so it is, and I am the grantor and the trustee typically during my life and completely control the assets in a trust. So it should be something that a mortgage company approves the transfer to the revocable trust, or you can just do it at closing. Say I have a revocable trust. I want that to be where I hold my house, and property taxes can be paid. That shouldn't be a problem. So in terms of property taxes or mortgage, homeowners insurance, the revocable trust should not get in the way of that. Sometimes you do have to explain to the mortgage provider up front that I want to take title. I have this in my trust. Or if you're buying a house, you want to explain to somebody, I want to take title in my revocable trust. You might have to show it to them, but it shouldn't be a problem. So
and just, I know we have a lot more to get through, but one more question. What is the difference between revocable and irrevocable trust?
That is a great question. A revocable trust is one that I can change through amendments or revisions at any time. So my husband and I have a revocable trust. It is really purely for probate avoidance, and we can change it at any time. If one of us dies, the survivor of us can change it at any time. Not all trusts are joint trusts, but that's how we have ours set up. An irrevocable trust is one where the trust is set up and cannot be changed. So if you set up an irrevocable trust, the trust agreement will say that you have no right to amend the trust or change it or terminate it. So it's kind of set in stone. There are mechanisms to adjust for changing circumstances when required, but an irrevocable trust, the key I want people to know is that you're giving up power. The power that you have over the assets in a revocable trust doesn't exist in an irrevocable trust. I don't think everybody needs an irrevocable trust. That's not one of the basic estate planning documents that I'd recommend. Your revocable trust will become irrevocable at all the deaths of the grantor. So for my husband and I, who I should say live in Kentucky, so that is why we have a joint trust. We have a joint trust. When both of us are gone, it becomes irrevocable. No one can change it. So irrevocable trusts are used for life insurance planning. Irrevocable trusts are used a lot more for when you are doing tax planning, when you are making gifts during life, to utilize, to use that estate and gift tax exclusion amount that's available to you. Irrevocable trust can also be used for charitable trusts. So if I want to have a trust where NKU is the beneficiary and I want to retain an income interest, I can set up an irrevocable trust that does that. And that gives me an income tax benefit from doing that. So that's kind of outside the scope of this conversation. But if you'd like to talk about that, you're more than free to contact me and I'm happy to walk through that. I'm sure Kyle and Amy would also be as well. So that's really high level, the difference between a revocable and an irrevocable trust. For probate avoidance, you just need a revocable trust, I would say, unless you have other issues that you're trying to plan for. Might be a good idea to go to the next slide since we're on talking about trusts. We've talked a lot about avoiding probate and maintaining privacy. A few down from that, reducing gift and estate taxes can be a possibility. I want to go back up to special needs planning. Trusts are really important if you are leaving assets for a beneficiary who has some special needs, and those are tricky to define. There are statutory definitions of special needs, and then there are just people who you want to make sure that you're leaving them assets in a way that doesn't disrupt benefits that they might be receiving because of circumstances in their life. So if you have a child or a grandchild or somebody who you're leaving assets for who is receiving Medicaid or some kind of need-based public assistance, you're going to want to leave a certain kind of trust for them that ensures that the trustee has the ability to make distributions to them without disqualifying them from public assistance that they might either now be receiving or receiving in the future. So that's a really important thing to bring up with the attorney when you're going to have these conversations. That's a different kind of trust than just one that is designed to be set up for somebody who doesn't have special considerations. Asset protection is another benefit of a trust. If I leave everything outright to my daughter, then if she has some sort of event of liability, either personal liability, professional liability, if she is married and has a divorce, assets that are in somebody's name are going to be more reachable by creditors than if they are set aside in a trust. The other benefit is that it's managing the transfer of wealth to the next generation or to charity. So again, maybe I want to leave assets to my daughter if my husband and I are both gone, but she is 7 right now, and we have more life insurance than she would know what to do with. And when she hits 18 or 21, she would get it if I didn't have it in a trust saying, trustee, this is for my daughter's benefit. Please spend it for her health, for her education, for her maintenance, for her support. It's a really broad standard, but don't give it to her outright. And then we currently have it set up where she will get distributions over time until the trust is exhausted, but there's not a day that goes by that I don't think about how we should probably change that. So you can leave assets to somebody, and as long as they are in that trust, they can get the benefit of the asset, but it provides them some asset protection. It can also provide them with some estate planning of their own. You can have a trust drafted in a way that if the assets are held for the benefit of someone, that those assets are not included in their taxable estate. So life insurance is something to think about. If you have significant life insurance and young children, that death benefit is going outright to them unless you have some kind of trust in place that stops that. Or if you're older and you've just built up some wealth, think about whether you want that to go to your children, and think about whether if you gave it to them outright, let's say you have a son or daughter and you're leaving assets to them and they are married, would you want your assets to go to a surviving spouse of your child if your child died prematurely? A lot of people think about where their assets might go after their death, and they want to ensure that assets are held for their children or their grandchildren. Or if you're leaving assets to somebody outside of your family, where would you want them to go if that person died without using all the assets? So if I name my friend's child as the beneficiary of a trust, if they died, where do I want it to go? Should it go to NKU then? If there are assets left, it's a bigger conversation. And the benefit of trust is that you can have a say in that. I don't see it so much as controlling beyond the grave. I just see it as a tool that you're going to use for a lot of other reasons. And it's worth thinking about what the next generations are going to do with that wealth. And charitable gift planning is the other big reason to have a trust. I think that if you have you want someone to benefit from the assets during your life, but then at the end you want to have a charity get anything left over, that's a charitable remainder trust. That's a great tool. There are also charitable lead trusts that you can set up where a charity gets an interest for a term of years, and then family gets it. So maybe you have enough wealth that you want to set up something like that to benefit both your family and charity. So I'll pause for questions there before I move on. If there are any, Amy.
So I have one question. Should I make an individual or an institution as trustee of my trust?
So I do have on the hat of a corporate trustee, Trust Counsel. I will acknowledge that fact, but I will also say this. I learned pretty early on in private practice that having an individual trustee was fraught with some complications. The way I've told people about it since, it's been almost 2 decades now that I've been explaining to people, if you name an individual trustee, you are changing the relationship between that person and the beneficiary of the trust. So you may have someone you want to be the beneficiary of a trustee, let's say it's your child, and your brother is an accountant or your cousin is an accountant, and you think they'd be good because they could file the tax returns. That may well be true, but you're also putting someone in charge of assets for someone who before they were just cousins or an uncle and nephew or something like that. So the way I say it is, by naming a corporate trustee, you're allowing people to come to the Thanksgiving table and not be upset with each other because distributions were made or not made in a way that people were happy about. I think that also it can be a long-term job depending on what you set up. You need someone to, and I think we could go to the next slide. Is that the case here? Yeah, the complex role of a trustee. A trustee makes a lot of decisions. I've talked a little bit about discretionary distributions. Let's say somebody comes to the trustee and says, you know, I'm 16, I would like a car. I think it should be a Maserati, and the trustee thinks, I think it should be a 2000 Civic, and there is some discord there. A corporate trustee is going to be better just say no, and then you're not upsetting a relationship again. Depending on the terms of the trust, you need to make timely income distributions in order to comply with the trust agreement, the trust code, and for tax reasons. There is going to be investment of the assets. You're going to need to make sure that you follow the Uniform Prudent Investors Act in whatever state this is, and make sure that the portfolio and the assets are being managed correctly. You need to comply with the trust code laws on providing statements to beneficiaries. There will be state and federal income tax returns for the trust. This is, again, after you're like, revocable trust, you're still in control of the assets. This is more so after you're gone and your revocable trust has become irrevocable, or when you set up an irrevocable trust during life. And then there's tax reporting to the beneficiaries. They will need to receive K-1s and other information from the trustee in order to file their own personal taxes. So to me, it's a big ask to ask somebody to serve as a trustee, especially when it's going to be potentially some decades if you've got young beneficiaries where they're serving. Finally, individuals are going to have life expectancies, and a corporate trustee just has the expertise and is probably not going anywhere. So that's my response to that. Okay, let's go to the next slide then. Once you have your plan in place, there are a bunch of reasons why I would review your plan, when to review the plan. When you retire is a great time. Your assets are kind of shifting around. You've gotten to a point where your income needs are changing. You're at a different point in life than you were when you first started working. I think that's a great moment in time to look at it. Marriage, not just your own, but your children's marriage. Do you like who's coming to the table? I think birth or adoption of a child is a good time. Financial responsibility of a child or irresponsibility as you watch your children grow. Do you like how they're managing money? Do you want them to get all of your wealth all at one time? Or do you want to think about whether a trust is a good idea for them? A divorce, again, not just your own, but the divorce of a beneficiary, of a child or whomever might be named. The death of a spouse, same thing, yours or your beneficiaries. Change in health or serious illness of a family member. A receipt of inheritance, just because that can change your net worth suddenly and make you rethink how you've got your current plan in place. If you move to another state, that's a good time to just pull it out, look at it, probably find a local attorney to make sure there aren't changes you should make based on the local laws. Acquisition of property in another state, going back to probate just for a second. If you own property, if you live in Ohio, let's say, and you own property in Kentucky or any other state, you're gonna need, and that property is in your name with no joint owner or beneficiary designation, you're going to have to open a probate estate in the state of your residence, and then another estate where the real estate is that you might own. So trusts can also help there. You can put your other property in other states in the trust name, and then you won't have to go through probate in multiple states. If you've named an executor or trustee who's an individual or a guardian of your children, if that person dies, pull out that will. Change in tax, property, probate, or trust law. Your financial advisor hopefully is going to keep you in the loop about these things. I know we're talking to our clients all the time about changes on this, but if they're making headlines in the Enquirer, then probably time to look at your plans, because it's probably a big change. Change in beneficiary attitudes. I alluded to this a little bit. If you've got children who just change how they are going through life in some way, and you think that money might not be a great thing for them to get in the way you have in your plan, probably a good time to review your estate plan. Change in insurability for life insurance, or change in a business interest. If you are a business owner and you have a liquidation event where you're getting out, you're putting the business succession plan into place, it's a good time to review your estate plan, which might have contemplated you owning that business. But now you've got either liquid assets or some other kind of asset. You want to review the plan to make sure that is handled appropriately in your estate plan. So those are those. If we want to move to the next slide, just really, we've talked a lot about these. Typical trust clients want to avoid probate. They're also planning for incapacity. This is the one I think I've talked about the rest of these, but for incapacity purposes, we talked about the power of attorney, and that's a really important document to have, but you'll remember that I said that that just controls assets that are in your name. If you set up trusts and fund them during your life, which is a really important part of this, is you can set up the most beautiful trust agreement, but if you don't point assets toward it or title assets in the name of the trust, then it won't work. So I personally recommend a lot of times that to the extent you can fund your revocable trust during your life with your house, with your taxable accounts, business interests, things like that, you should do that. And I say that because your trust agreement controls those assets then. It provides instructions to your trustee about how to spend those assets. So your power of attorney gives someone authority to deal with assets, and your trust agreement controls the property held by the trust, which means the trustee is in charge of those assets, which means that they will look to the trust agreement about how to spend it. That's particularly important in times of incapacity. If you want to ensure that a spouse is provided for during your incapacity, that you continue to support children, especially adult children, if you're helping them still. They might be the age of majority. So someone under a power of attorney might say, well, I have authority to spend money, but that child is 21. Is it in their best interest to spend the money on their child or them? They're incapacitated. Your trust agreement can say, provide for my children, even if I'm incapacitated in this way. So I think incapacity planning is another really important reason to have a revocable trust. It just provides more guidance. It's authority, but it's also guidance. And I think the trust is a great tool for that. We talked about high net worth families, very typical trust clients, private business owners. I will say with respect to probate, if you are a private business owner, if you have partners or employees and your private business goes through probate and has to go through some kind of emergency valuation that's now going to be public record, that's probably not going to be the best thing for the business. But if you have it in trust, that's all private. So it's just going to be a much different scenario. So I would encourage you, if you're a business owner, to talk to your attorney about setting up a trust. And then asset protection trust. Ohio has legacy trusts, which are self-settled. You set up your own trust and can be a beneficiary of that trust, but have some protection from creditors. That's a pretty specific type of trust that I wasn't going to spend a lot of time on, but if there are questions, I can answer questions about that. So I think the next slide is the end of my presentation. So I would love to take questions if there are any at this time, Amy.
Not yet.
Great.
They come in.
Awesome. I feel like this is a lot of information that I'm throwing at people. So if I am happy to, my email is there on the screen. If you have a question that you want to ask that you want to remain between us, I'm happy to answer questions to the best of my ability. I do not practice law in a private setting, so I can't draft any documents for you, but I'm happy to maybe point you in the right direction in terms of whether you might be a candidate for a trust or what I'd recommend for you, and even get you to an attorney if that's appropriate, since I work with a lot of the attorneys locally.
There's a question about the recording being provided, and yes, we will send out the recording after the workshop. Kyle will be sending out the recording in a couple days, so you will receive something from us.
Mary, as a parting thought, I'm sure there are some people on the call that maybe haven't drafted their will yet. Would you say that whether they've drafted it yet or not, they already have one and the state has just written it for them?
That's a great question, Kyle. Thank you. Yeah, everybody does have a plan. It's just going to be controlled by statute or what you say. So if you have no will, either, like I said, your beneficiary designations or the contract that you have with a financial institution will control. If something's in your name, the state will say how you get it. In Ohio, if I want to give you an example, if you have a second marriage and a blended family, your surviving spouse will not get everything and your children will not get everything. There will be a split. So, and in Kentucky, if your house is in your name and you don't have a will, then your surviving spouse might be sharing that house with their children. So I would always recommend having a will at a minimum. I think a lot of things can be controlled with beneficiary designations, but I think there's still, especially in Kentucky with real estate, Ohio allows for a transfer on death affidavit to be filed so that you can avoid probate and leave real estate to a beneficiary or beneficiaries. Your attorney can tell you if that's the appropriate solution. You can also have a TOD to a trust in Ohio. That's allowed, but Kentucky does not have any such thing. So I really recommend that in Kentucky, just for real estate alone, that you go to an attorney. Either, again, I would just set up a trust. I don't think there's any harm and there's only benefit.
Great. Thank you for that.
Yeah.
Well, with that, I think I'll move to wrap it up. Anything else you'd like to add, Mary?
I don't think so. Thanks for having me. I hope it was helpful to people. I feel like I was a fire hose of information, but hopefully it at least inspires people to talk to their attorney. It's really something that you're doing for your family. I know it's not fun to think about what happens when you die, but I think that since it is going to happen to all of us, I do think that it's the best thing that you can do to provide for your children in your family or whoever your beneficiaries are, just because they will be grieving the loss of you, and then to have something that's in order for them to do things as you wanted is a real gift to them in that moment. It's the last thing they can do for you. So I would just encourage you to get a plan or to review your plan if you have one.
Yeah, thank you for that. I shared with you that our family had been through some loss, and certainly with them having done planning beforehand, it was helpful to us and gave us some peace of mind. So certainly having that plan and knowing where you're heading can be very, very helpful to those that you name in your estate plans.
I agree.
And Mary, thank you so much for joining us today. We really appreciate it. All the information, although you term is, drinking from a fire hose, you're informative and enlightening. So we really appreciate it.
Thank you. Thanks for having me.
Before we say goodbye, I'd like to let you know that my office will be sharing a quarterly newsletter in the future. It's going to be an e-newsletter about financial planning, ways to better facilitate charitable interests, market news, and more. In addition, there's a lot of helpful information on our website regarding ways to support NKU at nku.giftlegacy.com. Be sure to check it out. If you have any questions, please feel free to reach out to me directly. I'll include my email and phone number in the follow-up email that Amy referenced earlier. As I mentioned earlier, please let us know what other topics you would like for us to cover as we continue to develop these personal development workshops so we can continue to bring useful and empowering content to you. And finally, thank you to Johnson Investments, Mary Burns, and Amy Wiley for making today's workshop possible. It was great and hopefully informative and helpful to all of you. Thanks again. Have a good day. Bye-bye.